So I'm Seetal Kalantri. I'm an advisory board member of Seattle's Asia Society. I'm also a professor of law at Seattle University School of Law, as well as associate dean and founding director of the Round Glass India Center. So it is my job to introduce our wonderful keynote speaker, and I wanted to just say a few remarks about where we are today. Right, we are at a pivotal moment in history, as democracy faces challenges around the globe. The importance of dialogue between India, the world's largest democracy, and the United States, the world's oldest, has never been greater. In both countries, the judiciary serves as the final safeguard against executive overreach and the erosion of long-held constitutional values. As a law professor who has spent nearly 2 decades studying and writing about India, including authoring a book on the Indian Supreme Court, I find it very shocking and regrettable that American legal institutions and law schools devote so little attention to the Indian judiciary. We have today so much to learn from it, especially at this critical juncture. In India's parliamentary system, where the executive is drawn from the legislature, the Supreme Court often stands as the only meaningful check against government power. Indeed, the Indian court has faced many threats to its independence over time, including court packing schemes, among other things, after the emergency. In response, the Supreme Court of India has developed several innovative institutional tools to safeguard democracy. One such innovation is the collegium system, through which the Chief Justice of India and his 4 most senior colleagues nominate their own justices to the Supreme Court. That's right, the executive has very little role. Another is the basic structure doctrine, where the Supreme Court has decided that they can declare constitutional amendments unconstitutional. Can you imagine that? They also protect minority rights, such as right to housing, right to food, rights of women, and transgender. I think the Indian judiciary's creative and courageous efforts to protect democracy and minority rights are something we can learn a lot from. And there's no one better to talk about this than Justice Surya Kant, whom we are so honored to have here. He currently serves as a justice of the Indian Supreme Court, not just, but awesome that he's a justice. But in 2025 of this year, in November, he will become Chief Justice of India. And he's a wonderful person. I've known him for 10 years, and he's too modest to say so himself, but he will become possibly the second most influential figure in India, next to the Prime Minister. The Supreme Court of India is the final court of appeal for over 20% of the world's population. As Chief Justice, Justice Surya Kant will oversee the entire judiciary, setting rules and policies for courts across the nation. India's unitary legal system, unlike ours in the United States, is in charge of all courts. There are no state courts that have the final say on certain issues. The Supreme Court of India has the final say. Justice Surya Kant earned his law degree from the Maharishi Dayanand University in 1984 and began practicing in the district courts that same year. In 2000, he became the youngest ever Advocate General of Haryana and was later designated a senior advocate, which is a very high and honorary title in India. He served in the High Court as a judge starting in 2004 in Punjab and Haryana. Then he also served as Chief Justice of the Himachal Pradesh High Court. And in May 2019, he was elevated to the Supreme Court of India. And as I mentioned, beginning November 12th, 2025, he will become the Chief Justice. So please join me in giving a warm welcome to this keynote address given by Justice Surya Kant. Please join us.
A very good afternoon to all of you. The President and other office bearers of the Asia Society, Northern California, very senior officers, including the Acting Consulate General of India and other senior officers from the Consulate General here, a very distinguished audience of different countries I can see representing here, some senior advocates who are also present from India, from Delhi, some of the very distinguished non-resident Indians who are also present here, and Professor Sheetal Kalantri, whom I always rate as one of the finest jurists of this generation for her contribution in the legal education, distinguished guests, policymakers, and all other friends from different parts of the world. I am deeply honored to address you today at the Envision India Conclave, an inspiring platform where vision meets dialogue and innovation meets purpose. As we gather in this vibrant city of San Francisco, a global epic center, as I call, of technological ingenuity and civic dynamism, it is fitting that we reflect on the future of one of the most vital pillars in any democratic republic, namely, as Professor Sheetal Kalantri has already hinted, about the judiciary. Since I represent the Indian judiciary, I proudly say that the Indian judiciary today stands at a remarkable juncture. It faces a confluence of challenges and opportunities brought about by rapid societal change, disruptive technology, and rising public expectations. And yet, amid this flux, its fundamental task remains unchanged, namely, to serve as the vigilant sentinel of the Constitution. I have witnessed this transformation unfold not just in the cases we decide, but in the expectations citizens bring to the court and the tools we now employ to deliver justice. I hope to offer today a few reflections on this pivotal moment for the Indian judiciary, grounded in our democratic ethos and constitutional vision. Going into the brief historical resilience and contemporary challenges of the Indian judiciary, I may point out that India's judiciary is a product of its unique historical, civilization, and constitutional evolution. The dual character of the Indian judiciary is what sets it apart from others across the world. At the heart of our judicial system lies the ancient concept of dharma, a complex, multifaceted ideal that encompasses duties, righteousness, moral order, and justice. At the same time, Indian judiciary is a modern institution forged in the crucible of its constitution, an audacious document that sought to harmonize the values of liberty, equality, and justice with the plural and diverse fabric of Indian society. Since independence, the Indian judiciary has played a transformative role from the assertion of fundamental rights, as some of you might recall, in the landmark judgment of Case 1 and Bharti, that was in 1973, to expanding the scope of personal liberty in Menka Gandhi's case in 1978, when the Supreme Court said that even right to have passport is a fundamental right, and it is referable to Article 19 and 21. The environmental stewardship and social welfare jurisprudence are some of the remarkable contributions made by the Indian judiciary. This history is not merely about bold judgments. It's about the judiciary's willingness to listen, to hear the voices of the marginalized, the silenced, the forgotten, and the invisibles. It is about walking the tightrope between the law as written and the law as it ought to serve the society. But today, we confront a dramatically altered landscape: rapid urbanization, a burgeoning digital economy, gender-national shift in values, and the emergence of a data-driven public discourse have placed unprecedented demands on judicial institutions. I am reminded of philosopher Alvin Toffler, and he said so beautifully, I quote him, "The illiterate of the 21st century will not be those who cannot read and write, but those who cannot learn, unlearn, and relearn." And that is what precisely the challenge the Indian judiciary is also facing. This address, to my mind, holds true for institutions too, especially for those charged with interpreting the law in a society that is constantly reinventing itself. There are a lot of public expectations in a hyper-connected democracy, and I will just try to briefly touch that. In a digital democracy, public trust is no longer just earned through reasoned judgments. It must also be reflected in transparency, accessibility, and responsiveness. People today want courts that they are not only learned but also empathetic, not only efficient but also humane. They expect the judiciary to speak in a language they understand, to operate with a sense of urgency, and to adapt to the rhythms of contemporary life. The power of the internet and social media has made judicial decisions instantly available to a global audience. This digital transformation brings both accountability and vulnerability. A nuanced decision can be reduced to a headline or hashtag, stripped of its legal complexity. In this environment, how the judiciary communicates, how it explains its reasoning, and how it carries itself with dignity and restraint has become as important as the outcome itself. I earnestly believe that this change in expectations must be met not only by defensiveness, but with a thoughtful engagement. We must recognize that transparency is not antithetical to judicial independence, rather it strengthens public confidence. A judiciary that shares its processes, methods, and principles in clear and open terms undoubtedly empowers citizens to trust its workings, even when outcome may differ from personal expectations. Transparency can bridge the gap between judicial logic and public perception, allowing people to see not only what was decided, but how and why. Transparency alone, however, is not enough. It must be accompanied by an active effort to foster judicial literacy, helping the public understand the complexities of legal reasoning and constitutional values. As courts become more visible, so too must their work become more comprehensible. Legal awareness campaigns, simplified summaries of key judgments, partnership with educational institutions, and open dialogue forms can demystify the judicial functioning. This is not merely about educating the public, it is about inviting them into a shared constitutional consciousness where legal principles become part of everyday civic life. When citizens understand the safeguard of due process, the role of precedent, and the limitations under which the courts operate, they are better equipped to both to respect the judicial decisions and critically engage with them in constructive ways. Yet even as we open judicial processes to greater understanding and dialogue, we must remain vigilant about the dangers posed by viral misinformation and media trials. These phenomena threaten to distort rather than deepen public engagement. Misleading narratives, selectively edited clips of the court proceedings, and uninformed commentary on complex legal matters often obscure the factual metrics and legal reasoning that undergird a judgment. Without judicial literacy, transparency can be weaponized, leading to misinterpretation rather than insight. When judicial decisions are judged in the court of public opinion, before they are understood even in the court of law, the result is not civic empowerment, but confusion, cynicism, and ultimately erosion of trust. In today's hyper-connected world, we are witnessing the rise of a vast digital community, vocal, impatient, and often uninformed, whose engagement with law is shaped less by understanding and more by sentiment. Many among them expect court to deliver judgments that align with their transient emotions and impulses. When courts adhere to the rule of law and the foundational values of constitutionalism, what follows is not reasoned critique, but a barrage of trolling, misinformation, and many a times even personal attacks. This phenomena poses a subtle yet significant threat to the independence of the judiciary, especially in a globalized digital age. The challenge before us is not merely reputational, it is actually institutional, and it must be met with not timidly, but with the firmness and clarity of purpose that befits a constitutional democracy governed by reason, not rhetoric. Let us remember that in democracy, the legitimacy of the judiciary rests not on coercive power, but on moral authority and public trust. And that trust must be nurtured, not assumed. It is strengthened with people feel that the judicial system belongs to them, that it speaks their language, hears their concerns, and upholds their dignity. The road ahead requires balancing openness with responsibility, clarity with restraint, and engagement with integrity. In doing so, we reaffirm the judiciary's role not just as an interpreter of law, but as a guardian of constitutional values and constitutional morality in the public conscience. The technological turn is also quite important now that e-courts to artificial intelligence, all these new phenomena are infused in the judicial system, and I will briefly touch that. In our effort to build a more transparent, accessible, and trustworthy judiciary, one cannot ignore the sweeping changes brought about by technology in recent years. Over the past decade, the Indian judiciary has witnessed a quiet revolution, one driven not by statutes or judgments, but by technology. It has begun to transform courtrooms, case management systems, and legal research in India. The e-courts mission mode project has digitized and translated records, enabled online filing of cases, and brought in virtual hearings, development that proved crucial during the COVID-19 pandemic. Even as we return to physical courtrooms after the pandemic was over, the hybrid model is here to stay. In our Supreme Court, we now routinely hear cases via video conferencing, allowing litigants from remote corners of the country to participate without the burden of travel. I can, for example, share with you that on average basis in my court, I have, say, 60 to 70 cases per day, and out of them maybe at least 20 cases, the people appear only online from different faraway parts of the country, and they are permitted and they do argue cases while sitting in south or in the northeast or in any other part of the country. This technological advancement is part of our broader commitment to ensuring access to justice and making the justice delivery system more affordable and efficient. By leveraging technology, we are not merely modernizing court processes, we are fulfilling a constitutional promise, that promise of that justice must not remain confined to courtrooms, but it must reach the doorstep of every citizen. The journey of technological transformation, therefore, is far from complete. The digital shift has laid the foundation, but it is artificial intelligence that may define the next leap in judicial efficiency and innovation. Artificial intelligence holds promise for reducing administrative burdens, improving case flow management, and assisting in legal research. Predictive tools could help courts anticipate case durations and better allocate resources. Natural language processing may revolutionize translation services across India's linguistically diverse countries. Those who do not belong to India, I can share with you that we have different languages in different regions. And since the official language of the Supreme Court is English, so the people in those areas, they face difficulty in understanding the court proceedings. So what we have done is that we have introduced now an app which translates our judgments in 16 languages simultaneously. So all the judgments are made available to the consumers of justice in their own language. Similarly, the pleadings and most of the reasonings also, we try to provide them in their own language during the course of hearing. That we are developing so that not only in the Supreme Court, but even high courts and our district courts, because we have three-tier system, judicial system, so that this language barrier can be broken at all levels of our judicial system. But I must add here that artificial intelligence should be deployed very cautiously. It must operate within strict ethical parameters, respecting privacy, due process, and judicial discretion. Artificial intelligence can assist but cannot replace the uniquely human dimensions of judging, empathy, discretion, and moral reasoning. We should understand that there are human realities shaped by emotion, context, and compassion. Technology may assist us, but it cannot replace the moral judgment and compassion that justice demands. Another aspect of artificial intelligence and digital shift that merits due consideration is inclusivity. Digital justice cannot become a privilege of the digitally literate people. We must work to ensure that technological advancements do not exacerbate existing inequalities between urban and rural, rich and poor, connected and unconnected. Underscoring the idea of this substantive equality, a woman member of the Indian Constituent Assembly, please remember 1947 to 1948 end, when the Constituent Assembly was debating to form the Constitution of India, there were 15 women members of the Constituent Assembly, and one of them, Hansa Mehta, representing Bombay Did and Bombay State, she spoke very beautifully, and I oftenly quote her speeches. She said, and I quote, "We have never asked for privileges." She is talking of the rights, equality. We have never asked for privileges. What we have asked for is social justice, economic justice. These words, in my opinion, hold significance even in the present context, as it demands inclusivity, not merely symbolic, but to dismantle barriers and create real, structural pathways to equality. The same is true of digital democracy. It must rest on digital inclusion and equal access to justice. To this end, efforts must be multiplied to improve internet penetration in rural areas, develop user-friendly digital platforms in local languages, and offer legal aid services that are technologically enabled. Courtrooms must not only be physically open, they must be digitally navigable by all. Equally important is the need to ensure that marginalized sections, such as those living below the poverty line, senior citizens, women without independent livelihoods, and vulnerable children, are equipped with the necessary tools, whether smartphones, digital devices, or user-friendly software. As part of welfare scheme, providing such access is essential not just for inclusion, but to empower them to engage with it and to navigate the justice system with dignity and independence. With reference to the institutional integrity and judicial independence, I may point out that as we embrace these technological advancements, it becomes imperative to reflect on the foundational values that must guide their integration. Innovation must not come at the cost of constitutional or institutional integrity. In fact, the adoption of digital tools compels us to re-examine how we protect the principles of judicial independence, impartiality, and accountability in an age where the speed of information often outpaces deliberation. The next frontier of judicial evolution, therefore, lies not merely in adapting to technological change, but in ensuring that our core constitutional ethos remains inviolable amid such transformation. In navigating change, the judiciary must remain grounded in its basic principles, namely, foremost among them, independence. Judicial independence is not privileges of judges. Sometimes people misunderstand and mistake it. That when we talk of independence, as if the independence is for judges. No, it's not for that. Judicial independence is not a privilege of judges. It is a safeguard for citizens. It ensures that power, however popular or pervasive, is always subject to reason, review, and restraint. In the Indian context, this independence has been often asserted with courage, be it, as Professor Sheetal Kalantri pointed out, the introduction of collegium system in the matter of appointment of judges, or maybe when we struck down the 99th Constitutional Amendment of 2015, in whereby National Judicial Appointment Commission was sought to be introduced. That simply reflects the judiciary's firm resolve to safeguard its autonomy from executive overreach. These instances underscore that the independence of the judiciary is not self-serving. It is essential to preserve the rule of law and maintain the delicate balance of powers envisioned by our Constitution. At the same time, independence does not mean insulation. The judiciary must remain responsive to societal realities, open to criticism, and vigilant against complacency. Institutional reform is a mark of maturity, not weakness. We must examine our own functioning. Say, for example, delays in justice delivery system, pendency of cases, and sometimes inconsistent precedents. We must be honest to resolve and to improve. Transparency in our working efforts to make judicial appointments at all the levels, better case management, enhanced infrastructure, and mental well-being of judges and staff are not just administrative issues. These are foundational to judicial legitimacy. Furthermore, a transparent system of judicial review, public availability of court data, and inclusive consultation processes can help build a judiciary that is not just independent but also interdependent, reliant on the trust and collaboration of the other organs of the state and the people. Other organs are equally important, so the courts must be must have a regular understanding of how the legislature performs the duties, how the executive performs its duties, and that collaboration between the three organs of the state is extremely important. The future demands from us not perfection, but commitment. A commitment to the rule of law, an active stakeholder in good governance, to institutional renewal, and to ensuring that our structure evolve with the nation they serve. As we examine the institutional frameworks and ethical commitments that sustain the judiciary, it is equally important to explore the deeper normative vision that guides our interpretation of justice in a complex, pluralistic society. The idea of constitutional morality, grounded in the values of liberty, equality, fraternity, and justice, offers both a compass and a conscience for the judiciary. As we move forward, it becomes essential to reaffirm this moral vision not just in our judgments, but in the way we engage with India's diverse social fabric and uphold the rights of all citizens, especially those who are vulnerable. India's constitution is not a static document. It's a living charter of values. At its heart lies the principles of constitutional morality and enduring commitment by our commitment to justice, liberty, equality, and fraternity. As judges, we are duty bound not only to interpret the text, but also to animate these values in our decisions. This requires sensitivity to India's plural traditions, its diverse communities, and the evolving aspirations of its people. In recent years, constitutional courts in India have addressed issues ranging from safeguarding the rights of all genders, promoting women's empowerment to protection of fundamental human rights, alongside matters of data privacy, electoral integrity, and environmental protection. All these constitutional adjudications redefine a new set of legal rights. They also demonstrate a new architecture of the Indian democracy. The recognition of the right to privacy as a fundamental right by the Indian Supreme Court very recently in Puttaswamy's case reaffirmed the centrality of individual dignity in a surveillance-heavy digital age. As part of the broader affirmation of the inclusive promise of constitutional morality, Indian courts have progressively expanded the rights of accused and convicted persons. We have, through court decisions, granted conjugal rights to the convicts. We have granted them the right to be released on bail on completion of half of the sentence when their appeals are pending. And in some of the cases, we have even granted the right to contest for the public offices, even if someone who is a convict and whose appeals are pending. For that, we have laid down our own principles to be, of course, applied with a very strict parameter. But with all such influence comes to a profound responsibility. The exercise of judicial power must be tempered by humility and guided by constitutional boundaries. Courts must not supplant the role of the legislature or override the will of the people. Instead, they must act as facilitators of democratic dialogue, strengthening participatory governance, protecting minorities, and ensuring that the rule of law prevails even in moments of political uncertainty. Judicial overreach, however well intended, risks unsettling the delicate balance of power. True constitutional guardianship lies not in dominance, but in restraint, an ethos that reaffirms the judiciary's legitimacy in a vibrant democracy. Here I am reminded of what the father of the nation, Mahatma Gandhi, said, and I'm just quoting him. He said, "The true source of rights is duty. If we all discharge our duties, rights will not be far to seek." A judiciary imbued with constitutional morality fosters a culture of mutual responsibility between state and citizen, between right and duty. Let's think of a judiciary for future. What should be the vision and values? In a globalized world, judiciaries across nations face common challenges: climate change, digital misinformation, AI regulation, migration, and cross-border crimes. There is much we can learn from comparative constitutionalism and international best practices. At the same time, Indian constitutionalism remains deeply rooted in our own history and social realities. Our legal traditions are shaped by a multiplicity of cultures, languages, and belief systems. The solutions we must seek resonate with our local contexts even as we embrace global ideas. And I'm quite confident that the persons who belong to different jurisdictions, different regions, can do a lot in strengthening the transnational judicial dialogue, and their collaborations in different fields can really make the global democratic future a vibrant one. Before I end, I must ask myself, where does this journey lead us? It leads us to a judiciary that is more accessible, more accountable, and more attuned to the needs of a changing society. It leads us to judges who are not only legal experts, but also community listeners, social thinkers, and moral leaders. It leads us to an institution that embraces change without compromising character. In the last, I would say, the constitutional pledge we have taken to secure justice, social, economic, and political for all must be achieved with our commitment and with our hard work. This is not merely a legal task, it is a moral calling, and in fulfilling this calling, we must remain anchored in our constitutional values even as we innovate in form, method, and outreach. Thank you very much. Thank you for giving this opportunity. Jai Hind, Jai Bharat.